everybody. The Senate Labor Committee is called to order. Today on our agenda, we have Senate File 2533, and Senator Mann has joined us. That is the Senator's bill. And Senator Mann, if you are ready to proceed, tell us about your bill.
Thank you, Madam Chair. I do have an A4 amendment. Did you want to talk about that first? Or?
Oh, yes. Thank you for that. Yes, the A4 author's amendment.
Yes.
Do we have a committee member who would like to move the adoption of the A4? It has been moved by Senator Kupek. All in favor of the adoption of the A4, say aye. Aye. All opposed? All right, the A4 is adopted. To your bill.
Thank you, Madam Chair. So 2533 will prohibit stay or pay provisions, also known as TRAPs, short for Training Repayment Agreement Provisions, or also known as shadow student debt. These agreements require workers who receive on-the-job training, many times of dubious necessity, to pay back the alleged cost of the training if they leave their jobs voluntarily or involuntarily within a time range that can range from months to years, effectively trapping workers in jobs they don't want to be in. Some real examples of TRAP agreements. Stacy, who is a nurse, switched job between hospitals. The hospital she was working at had really poor working conditions, and 3 years later, she gets a letter in the mail saying that she owes the previous hospital $5,000 plus attorney's fees, and it is unclear to this day what exactly the training she received actually was. In nursing, TRAPs have been more closely studied, with studies finding that up to 45% of new nurses are bound by these agreements versus 10%, or about 10 to a quarter percent of nurses who have been bound to them who have been on the job for 10 years or longer, meaning that their prevalence is increasing. So across sectors, we know that the use of these clauses, again, are going up. Now, specifically in nursing, these agreements are more common and more egregious in hospital markets that feature a high level of ownership concentration, and numerous reports suggest that hospitals with higher rates of unsafe working conditions and higher rates of unsafe patient conditions use these agreements more often, with payback amounts that range from $5,000 to $50,000. Some of the training described that costs this much money includes monthly webinars on stress management strategies. $50,000. We have Casey, who worked as a hairstylist and was required by her employer to pay back training fees despite the fact that she went to cosmetology school and paid her own tuition. She had to pay $20,000 for leaving her job before the year was up. We have Brianne, who worked at PetSmart, and this is a very well-known case, who was a dog groomer, and they told her she owed them thousands of dollars for, again, on-the-job training that she received despite being no training schedule, no consistent trainers available, and she was grooming dogs for paying customers, not training from day one. Brianne makes minimum wage. And then Jim and David, who are both truck drivers, who left due to poor working conditions from the same company. One was charged $5,000. The other was charged $6,000 for leaving. Both stated that the training they received consisted of a co-driver, so just being in the truck with someone else. And one of them said that even after this training, he still couldn't back up his truck due to lack of actual training. And lastly, we have a female truck driver who was sexually assaulted during her training on the new job. And when she told her supervisor, she was told that without a video, they couldn't do anything about it. And so she quit her job because her trainer, her co-driver, was the man who sexually assaulted her. She was in a trap, and she was asked to pay $9,000 back. So the trainings in question can range from preparation for recognized credentialing to very basic company-specific tasks that don't actually offer any transferable skills, and the costs that the worker will have to repay can be completely invented by the employer and can include high interest rates, attorney's fees, and the ability for the employer to hold final paychecks and retirement balances. Traps are not new. They began many years ago for high-skilled, high-wage jobs, but now we are seeing their prevalence in low-wage jobs, essentially creating a new class of indentured servitude, especially in jobs that are disproportionately held by women and people of color. This includes nursing, like we discussed, EMTs, truck drivers, retail workers, construction workers. It is estimated that about 10% of the U.S. Working population is bound by traps, which includes 1 million of workers in middle to low income jobs. So overall, these agreements reduce worker mobility, they reduce bargaining power, they take away people's freedom. If you believe in the free market, trap agreements are the exact opposite of that. That's it, Madam Chair.
Thank you very much. I believe that we have a few people who have signed up to testify. We'll go ahead and proceed with our testifiers, and then we'll have some discussion. First up, virtually, we have Chris Hicks. All right, I think we see you. Welcome to the Senate Labor Committee.
Thank you. Can you hear me?
Yeah, you're a little bit quiet, so if you can just make sure to try to speak up, and so we can hear you clearly, but we can hear you. Welcome to the Minnesota Senate Labor Committee. Please introduce yourself for the record and proceed with your testimony.
Hi, thank you for the chance to testify today. My name is Chris Hicks. I'm a senior policy advisor at Protect Borrowers. We're a national nonprofit policy organization focused on household and consumer debt. We're proud to support Senate File 2533. Our organization spent more than 3 years studying the effects of stay-or-pay contracts on workers, honest businesses, and the broader economy. We're currently litigating several cases against the enforcement of stay-or-pay terms. We've published several reports and legal articles on the topic, and we regularly engage in legislative and regulatory advocacy related to stay-or-pay provisions. As the term suggests, stay-or-pay contracts are employment terms that force workers to pay their employers if they leave their jobs. These terms cement a chilling effect on workers who might otherwise assert their workplace rights. No matter why you leave or what or where you go to work afterwards, if you even work at all, no matter what, if you leave, you have to pay. This builds on an existing power imbalance in the workplace. Employers can still terminate workers at will, but under stay-or-pay terms, workers cannot financially afford to exercise their reciprocal right to quit at will. These terms are forced on workers as a condition of employment, allowing firms to use the threat of debt collection or litigation to lock workers in place, limiting their mobility and bargaining power. When they do leave, these workers are hit with a crushing financial penalty just because they had the audacity to quit their jobs. This puts workers in a bind. Stay and endure unlawful and unsafe workplace conditions, which regulators, lawyers, and judges across the country have suggested create an unlawful modern-day indentured servitude, or leave and face a financial penalty. The most common types of stay-or-pay contracts are training repayment agreement provisions, better known as traps. Traps are becoming increasingly prevalent throughout workplaces across the country. A 2024 study from Cornell University found that 1 in 12 workers in the United States is subject to a trap. These terms require workers to receive so-called on-the-job training, regardless of the quality or necessity, to pay back the supposed cost of this training to their employer when they leave their job. Often, the purported cost dramatically exceeds the actual value of training, and in many cases, the training is for the benefit of the employer rather than the employee. In other types of stay-or-pay contracts, employers have demanded that departing workers pay them for the cost of their replacement salary, liquidated damages, and even lost profits. The increasing use of stay-or-pay contracts has raised concern by state lawmakers and regulators. In 2025 alone, a dozen states coast to coast took action to limit or ban the use of stay-or-pay contracts, including California, Colorado, Indiana, New York, and Wyoming, which all passed new laws protecting workers from these debt traps. And a half dozen state attorneys general brought enforcement actions and lawsuits against companies in numerous industries to combat the growing use of traps, including here in Minnesota. This bill would protect workers' ability to seek employment from multiple employers without restrictions, benefiting workers, honest businesses across Minnesota. I applaud the sponsors and legislators for taking up this issue so directly. It's very timely. Thank you for the chance to testify, and I'm happy to answer any questions.
Thank you very much for your testimony. Are you able to stick around while we have discussion and stay for questions?
Yes.
Okay, thank you very much. And just for the record, could you also tell us where you're testifying from today, since you're joining us remotely?
Yeah, I'm based in Kansas City, Missouri.
Thank you very much. Appreciate that. Next, we have Anna Prakash. Good afternoon. Welcome to the Senate Labor Committee. If you would please introduce yourself for the record and proceed with your testimony.
Good afternoon, Madam Chair, Senators. Thank you for the opportunity to speak in support of this bill. My name is Anna Prakash. I'm a partner at the law firm of Nichols Castor in Minneapolis. I have been a lawyer for more than 20 years, and in the last several years, I have been lead counsel on at least 8 proposed class actions involving stay or pay contracts, which involve somewhere between a couple hundred up to more than 5,000 workers who have been impacted by these types of contracts. I'd like to use this time to share with you 5 key takeaways from my experience that speak to why this legislation is so important. So first, there are very few laws that are designed to address this issue. And while creative lawyering can get us into court, it is still an uphill battle for workers. It's an uphill battle particularly because, for example, Minnesota workers who have signed these contracts can, by virtue of forum or venue or choice of law provisions, be forced to go litigate their claims or defend against claims their employers bring in places like North Carolina and Florida and places that are in no way related to Minnesota protecting its citizens and its workers. Second, this is the most vulnerable group of workers I have represented. For example, there are many American companies that recruit workers from other countries and bring them to the United States, including to Minnesota. These workers are eager to realize the American dream and have very little context for US contract law, but they sign, just as US-based workers do, because nobody expects that their job is not going to work out. And the result is that there is debt following them around. There is debt following them around because these companies report the debt to collections agencies, sell them to debt collectors, and send them to the credit bureaus, which impacts people's credit. Third, there is unequal bargaining power in any employer-employee relationship, but it is particularly problematic with respect to stay or pay contracts because, one, employers do not have an incentive to pay a competitive wage. So employers who don't have these contracts are trying to keep up, but they can't because they don't have a captive workforce in the same way that employers who use stay or pay contracts do. And second, there is no incentive for an employer to make the conditions of work good. I have had numerous clients who are nurses subject to stay or pay contracts who have testified in court, in deposition, that they fear for their safety and their patients' safety because the employer is not listening to the workers' complaints about what is going on at the job. They don't need to. Because, and this is my 4th point, the word trap is very appropriate. Without guardrails of law, these contracts begin to function as a penalty. It is a penalty for any worker who dares to leave before their employer says they can. And that, as the senator and the previous witness have explained, looks very much like indentured servitude. It looks very much like forced labor under threat of financial penalty. In fact, it looks that way because it is. And finally, a private right of action is essential for this to work. These workers cannot afford to pay a lawyer out of pocket, and lawyers cannot exist solely on pro bono services. I have declined numerous clients because either by virtue of the forum or the law or their particular circumstances, there wasn't a hook for it to make economic sense. And this bill, by providing for fees and penalties, provides that hook and allows people to be represented by lawyers. Thank you very much. I'm happy to answer questions now or during discussion.
Thank you very much for your testimony. If you would be willing to stick around, I think we'll go through all of our testifiers and then I'll open it up to the committee for some questions and discussion.
Thank you very much.
Thank you. Next we have Lauren Thorst. Welcome back to the Senate Labor Committee. If you would introduce yourself for the record and proceed with your testimony.
Good afternoon, Madam Chair, members of the Senate Labor Committee. My name is Lauren Schotthorst, and I'm the Director of Workplace Management and Workforce Development Policy for the Minnesota Chamber of Commerce, a statewide business organization representing more than 6,300 businesses across the state and 500,000 employees throughout Minnesota. A majority of our members are small and mid-sized businesses. The Chamber appreciates the opportunity to testify in opposition to Senate File 2553, legislation seeking to prohibit employers and employees from entering into written agreements or contracts that stipulate an employee pay back an employer a certain sum of money if the employee leaves the employment before the passage of a stated period of time for certain costs or reimbursements. These types of employee retention mechanisms are fairly common and vary. They include anything from relocation agreements and sign-on bonuses to retention bonuses and tuition reimbursement programs. Beyond that, you will find employer-supported professional certifications, immigration assistance, and employee loans as opportunities that employers have made available to their employees in exchange for a reasonable term of service. There is nothing unconscionable about this, nor should it be against public policy. It is reasonable to expect a return on this type of discretionary employer investment in employee development support and training portfolios. Despite what you've heard today, these agreements are generally mutually beneficial when done properly. A blanket prohibition on these types of agreements negatively impacts employees, as employers simply won't make these arrangements available. While the amendment seems to contemplate some exceptions, it doesn't go nearly far enough. Industries across Minnesota's diverse economy are experiencing several troubling trends, including high costs and steep increases in regulation and business mandates on workplaces that are already heavily regulated in Minnesota. Minnesota's employers and employees are counting on lawmakers to work toward an agenda for economic growth, making Minnesota's economy stronger, more vibrant, and more viable. Instead of reducing costs or making it easier for Minnesota businesses to remain competitive, this bill takes the opposite approach. Balance is necessary to protect public interest and promote economic growth. The Chamber is looking forward to working with members of this committee in a bipartisan fashion to pursue solutions that are reasonable, that strengthen the economy, keep costs manageable, and reduces barriers and other burdens undermining growth. Because this bill would impede Minnesota businesses and our competitiveness, we respectfully encourage a no vote on it. Thank you.
Thank you for your testimony. Next, we have Dalton Danielson. Welcome. If you would please introduce yourself for the record and proceed with your testimony.
Thank you. Good afternoon. Chair McHugh and members, my name is Dalton Danielson, Fiscal Policy Director for the Minnesota Business Partnership. The Minnesota Business Partnership is an association of CEOs and senior executives from Minnesota's most innovative and respected large companies. The partnership represents regional, state, and global leaders in healthcare, med tech, agriculture, manufacturing, and more. Altogether, our member companies employ 1 out of every 6 Minnesotans. The Minnesota Business Partnership urges members to oppose Senate File 2533 as it stands now and consider the potential ramifications it has on Minnesota's workforce. As it stands now, amended by the A4, this bill would undermine recruitment, training, and advancement opportunities for Minnesota workers by removing a tool employers use to make long-term investments in people and their careers. Right now, Minnesota employers compete nationally and globally for talent. To attract workers, especially into high-skill, high-demand roles, employers often front the cost of training, certifications, onboarding, and even relocation. These investments can take months or years to realize. Senate File 2533 broadly prohibits and penalizes stay or pay arrangements tied to those tangible investments, even when they are transparent, limited in purpose, time, and mutually agreed upon. The result of this legislation will not be more opportunity, it will be less. When employers cannot reasonably protect an investment in training, they respond by reducing access to upfront training and potentially hiring only fully credentialed candidates or shifting opportunities out of state. This disproportionately harms entry-level workers, career changers, and workers seeking advancements who rely on this employer-sponsored training to move up. This bill also risks slowing internal advancement. Many leadership pipelines depend on rotational programs, apprenticeships, and advanced technical training or education. If those investments carry uncompensated risk, employers may begin to narrow access, again, limiting upward mobility for the very workers this bill seeks to protect. To conclude, a one-size-fits-all prohibition will make Minnesota less competitive and reduce pathways into good jobs or new opportunities. Chair McEwen, committee, thank you for the opportunity to testify.
Thank you very much for your testimony. I believe also because the subject of apprenticeship type issues was just brought up, that we do have Chris De La Forest here, and doesn't need to offer any testimony, but is going to be here if we want to discuss that or have questions, more questions about how this provision would affect registered apprenticeships. But with that, I would like to turn it back over to the lead author of the bill, Senator Mann. Do you have any other comments that you'd like to offer us before we have some discussion and questions?
Thank you, Madam Chair. So just a couple things. Certification programs, retention bonuses, employee loans, moving costs, everything that we heard as opposition. If you look at the amendment and those things fit under subdivision 4, none of that is prohibited. So those are very much not what the bill is doing. And then I just found it really interesting that there was testimony that said, despite everything you've heard today, these agreements are mutually beneficial. Well, I think because of what you heard today, we now know that these agreements are not mutually beneficial. That's all.
Thank you very much, Senator. Members, questions or discussion? Yes, Senator Dornick.
Thank you, Madam Chair. First, I guess I'd like to hear the path of the bill. I'm assuming it has to go to judiciary. Is that correct?
Yes, Senator, it is our plan today to, if the committee sees fit, to pass this on to judiciary, and then also it is our intent to ask for the bill to be returned to the Senate Labor Committee.
Okay, thank you, Madam Chair. Well, no other stops then?
I do not believe so.
Okay. So another question I'd have would be for Dolly, the enforcement. I'm assuming you've talked to Dolly on, I know they have a lot of enforcement with the other mandates and laws that we've passed. Senator Mann, I'm just curious of if you can answer that question, or if I need to bring, or if you'd like to have Josiah come up to speak to that.
Senator Mann?
Is Dolly here, Madam Chair?
Yes, I do believe that we have some representation from DLI. Welcome. Did you have an opportunity to hear the question?
I believe it. First, I'm Josiah Moore, Legislative Director at Department of Labor and Industry.
Thank you.
I could use clarity on what the question is.
Very good. Senator Dornick, would you just like to focus it a little bit? Thanks.
Madam Chair and Mr. Moore. So basically just the enforcement, you guys are going to be enforcing it, and I know you have so much other stuff, and so how are you going to, you need to hire more people? How are you guys doing with kind of the issues that you're dealing with now, let alone another one tacked onto that?
Mr. Moore.
Thank you, Chair. Thank you, Senator, for the question. We did just complete a fiscal note on the bill, and it shows some costs to the department. We projected an additional, it looks like 1.44 FTEs associated with the work under this bill. So that would cover, you know, the costs and the work we do associated with this.
Follow-up, Senator Dornick.
Thank you, Madam Chair. Thank you, Mr. Moore. So to the author, just looking at the transferable accreditation, can you just give me a few examples, Senator Mann, of what exactly define that a little bit more?
Senator Mann.
Thank you, Madam Chair, Senator. So lots of different jobs have credentialing, which would then make you a candidate for moving up. Nursing has some, IT, I imagine, has some, So lots of different, across many sectors, you can have different credentialing that would qualify you then to move up the ladder.
Senator Dornick.
Thank you, Madam Chair. So I guess my understanding with the exemption, so if a business has a agreement, then there's a side agreement to the tuition and to pay back, or how does that exactly work in what this bill is trying to accomplish?
Senator Mann.
Madam Chair, so as long as the tuition or the credentialing is not a condition of employment, and there's a payment plan in place, the agreement specifies the repayment amount, and you can have a prorated repayment amount. And lastly, the agreement does not require repayment if the employer is fired, except fired for cause, then any of those things are a go. They are not prohibited by this bill.
Senator Dornick.
Thank you, Madam Chair. Thank you, Senator Mann. So the condition of the hiring doesn't require repayment. It's just a side agreement. That's what I'm hearing. Okay, I just want to clarify that. Thank you.
Very good. Senator Rarick.
Thank you, Madam Chair. Just a follow-up. I mean, I understand what a credential is, but you're labeling it as a transferable credential. Can you help me understand what you mean by it's transferable?
Senator Mann.
Madam Chair, so in many of these instances, the employer will say, we're providing training for this credential. But if you go to any other company, that credential means nothing. So it's any credentialing that it has actual meaning that you can take to another employer and they recognize that credentialing.
Any follow-up?
Yep. I got a couple other, for the most part, just going to be some comments.
Sure.
As I look at, especially with the amendment that we adopted on this, a comment was made that, you know, this exception is going to, it's going to incorporate the sign-on bonuses and the moving expenses that was brought up. As I read this, I do not see that. I see that we're making an exception for cost of tuition. And then the points 1 through 5 are points under that. But it's not covering these other things that the chamber brought up that are commonly used for this. So I think those are important things to keep in place. A few of the things I was going to say have been said already, but you know, I think what we're going to see, there are a lot of trainings that happen, and that's an investment into the employee, and they're gaining a skill which makes them better at their job, more employable, and I think you see that investment being willing to be made because you're going to get a return on that investment by the person staying there and working for you for a while. And I also look at in this amendment that we adopted, we also exempted this idea specifically for trade unions and the apprenticeship program, because we know that there is a lot of time and effort and cost that goes into the training. But by exempting that, we're admitting that the basis of this law has some issues, that it is not the answer. And it was said before, we're approaching, I acknowledge that the stories that you brought up need some addressing, that we need to figure out a way to deal with that. But this one-size-fits-all approach is not the answer. We have to allow for this training to continue. I think what we will see is many employers that have these high-skill jobs are going to say, it's not worth my time and investment to train people if I don't know they're going to stay, so I'm going to require that they have the training before they come here in the first place, which is going to require the person to have a lot of time invested, where they're being unpaid to get that training, and it's going to cost them tuition to get that training. In today's world, I think we're seeing so many employers saying, look, I'm not going to require you to go to a trade school or college or something. If you come here, I'm willing to give you the training we need so that you can start working for us. You can start making a wage instead of going into debt. And I think one of the comments that was made, are comparable to this, like if you decide you just want to change careers, that you shouldn't have to pay back for the training. Well, if I go to college and I pay for my tuition and I get into the workforce for about a year and I decide I don't want to do this anymore, I picked the wrong career, I don't get reimbursed my tuition that I paid for college. Those are things that, if somebody invests the time and the effort to train you, there is that cost, and that should be something that an employer, just because you decide to change careers, that I don't think that's their responsibility to say, well, I made this investment and now you're just going to leave and go somewhere else, whether it's in the same field or a different field. So I hope as this moves forward, we will have some discussion, because the one testifier mentioned that something about guardrails. This bill isn't about guardrails around pay and stay. This is just strictly prohibiting it. So I do think there could be some provisions that we could look at for guardrails to protect some of the stories that you were talking about, but just this blanket prohibition is going to lead to far less willingness to train people so that they can increase their skills. Thank you.
Thank you, Senator Wright. Senator Mann, would you like a moment to respond or offer any comments? We have other senators who want to make comment too, but I wanted to give you an opportunity if you wanted one.
Thank you, Madam Chair. Yeah, those exemptions that we talked about the intent is that they were covered by the amendment, and if we feel like that is not clear, we can certainly add more language for that. That is no problem. We added the apprenticeship language exactly for that reason, because they wanted more clarity. And it is not, I would say it's not up to the employer to train people. It is, if they don't feel like that's necessary. But I think it's also up to the employer to make sure that people have livable wages and livable working conditions. And because of these agreements, they completely abdicate the responsibility to do that. So I think that's one of the biggest issues that we're trying to deal with here.
Senator Umer Verbaeten.
Thank you, Madam Chair. It's my understanding that there's other states that have put some restrictions on, because there's sometimes a number of years that there's a threshold on. But just to clarify, currently there's no ban on these stay or pay provisions in Minnesota, even beyond a certain number of years. Is that correct?
Senator Mann.
Madam Chair, yes, that is correct.
And one of the testifiers earlier, Anna Prakash, I hope I'm pronouncing that correctly, just talked about how it can be difficult for employees to, I think, sue for damages. Could you actually come back, if that's okay, Madam Chair?
Yes.
Just wondering what the current recourse is. I know that this bill has private right of action included, which is why I'll go to judiciary, but I'd just like to understand currently what can a employee do? Can they sue on this, and then what sort of damages could they expect to receive?
Ms. Prakash.
Thank you. Thank you for the question, Senator. I think the short answer is that in Minnesota, there are very few remedies for this type of issue. I would say that around the country, there are perhaps other state laws where you could make a colorable argument that this is a restraint of trade and functions in the same way that an illegal non-compete would. The Trafficking Victims Protection Act, for example, prohibits forced labor under threat of serious harm. And if you're talking about up to $50,000, in one case, my client was sued for $123,000, that is serious harm. The other aspect of this is the Fair Labor Standards Act. When Senator Mann was talking about the PetSmart case. So in that case, because the workers had to pay back this money, it dropped them below minimum wage. And the tie-in with the Fair Labor Standards Act is particularly important, Senator, to your question, because the idea of a transferable skill, this thing that you gain, a portable credential, is baked into the case law in the Fair Labor Standards Act. And so it says something along the lines of, if you gain something from your employer that is above and beyond on-the-job training, right? Like, you start out at a job and you have no experience. You gain experience by working on that job, by learning the employer's system. That's called having a job. It's not this type of like specialized training that you can then take somewhere and say, look, here, I have this credential on how to work at ABC Business, because XYZ Business won't care about that. And so that's the distinction, and that's the distinction that I believe the amendment is trying to address. The difference between on-the-job training, on-the-job experience, things that happen in any employment setting, and something that is truly specialized, that truly gives you something that you can take out in the market as your own. And if your employer paid for that, like if your employer paid for you to go to business school, yeah, I get it. You, the employer, should have a way to recoup that money. But if what you are offering is on-the-job training, just the same as anybody else, something that isn't transferable, then what is happening through stay or pay contracts is essentially a restraint on trade. And I don't think Minnesota courts have considered whether the recent non-compete law would cover that, to your question. I think there are other states where that is more established, or there is a arguably stronger argument. So in Minnesota, this specific legislation would add clarity. It would add, it would really provide guidance with respect to what can be done in these types of situations. With respect to damages, certainly just the ability to hire a lawyer, one, right, through the private right of action. The other issues that you could make an argument for, because I believe this bill, in talking about remedies, doesn't foreclose anything else that might be allowed. We're talking about economic models of wage suppression, the types of things that are seen in antitrust cases. And so where that wage suppression requires an expert, where it requires an economist to come in, that is where you start getting into this idea of, well, we really hope that these types of workers are able to find representation that allows them to make those arguments as to damages. And of course, if workers have already paid, those damages are the out-of-pocket damages that you could seek under something like this.
Senator, follow-up?
Yes, thank you, Madam Chair. I appreciate the distinction between this like transferable credential and on-the-job training. In your experience with employees that have had to deal with stay or pay provisions, if they receive like a contract for, you know, this training that they're then going to have to repay if they don't stay, is there an ability to decline and still get the job, right? I feel like that's kind of at the heart of it. If you don't have an ability to decline and still do the work, it seems like that's training you need in order to do the job versus maybe just a nice to have transferable credential that, you know, employers offering and that you would help you at another place of employment. But I'm just curious what that experience has been when folks are first starting at the job, being asked to maybe sign something, and need to take that training in order to actually do the job.
Ms. Prakash?
Thank you, Madam Chair, Senator. That is a great question. So in my experience, these are employment contracts. It is the offer letter that is sent to the worker that says, sign here. And nobody reads all of their new hire paperwork, right? Oftentimes it's buried in a bunch of other paperwork. Oftentimes it is just the offer letter saying, if you want this job, this is the condition of employment. The problem is that often, and I'll use the nursing market as an example, employers are looking for nurses with an RN. So they already have that certification, that qualification, that education before they are hired. They come in and what they get, at least in my experience and what I have observed, is on-the-job training. And maybe they move up to like nurse level 2 at that particular hospital. But that is not something that is any different than saying, I've been a nurse for 5 years or I've been a nurse for 10 years. It is something that happens in any job. The difference is that in order to get this job, not only did they have to have the credential in the first place, but they had to sign a contract that said they would pay their employer if they left before a certain number of years were up.
Thank you. Yes, follow-up, Senator Rick.
Thank you, Madam Chair. Just to follow up, you were talking about the on-the-job experience, and I agree 100% with what you're talking about. There are skills that you learn when you work for a certain company, but what I'm seeing in this bill, what it would prevent would be, say, in a manufacturing setting, and you come on to the company and you're working an entry-level position, and the company decides that, man, you have a skill set, you could operate this CNC machine for us or something. And so then they're gonna say, look, instead of sending you off to school, because this bill is saying, if we send you off to a vocational school, we can recoup those costs of tuition that we might pay. But we're saying, look, we're going to bring you on, we're gonna put you beside one of our operators. We are going to train you. You're not going to be productive during this time. This person is also going to be maybe less efficient because they're taking the time to show you how to do this, train you in that skill. As I see it, this bill would say that when I am going to offer that employee this training within, that I cannot say, look, I'm going to give you this training over the course of the next 6 months, so you're going to get this new skill, and I can't require you to stay for 2 years beyond that after all of this time that I've invested into you to gain this new skill. That's not on the job training as such through your typical day of work. This is a specific training for increasing your skills that they are investing into you. Would you see that as something that should be allowable, that this bill is actually preventing from happening?
Ms. Prakash.
Madam Chair, Senator, thank you. The devil is in the details, and in the example that you provided, I think my question would be, at the conclusion of that period of training with a colleague, what does that worker have that would be recognized out in the labor market beyond experience? So if the company instead said, we're sending you to a trade school and you're going to get a diploma from Minnesota State or something like that, right? That's something that employee can take and show to another employer and say, look, I have this certification. And that means probably more than I have 5 years of experience at this manufacturing company and they provided me training. Now, it's up to the labor market as to what they value more, right? But in a world where we're trying to impose guardrails, as I said, and as you acknowledged, in a world in which we're trying to provide clarity, I think the case law that exists on whether there is a portable credential is really the thing to fall back on. And the example I would give you that is very similar to what you're talking about is preceptorships in the context of nursing. So almost anybody that is an entry-level nurse or a new nurse at a hospital, even if they've practiced for several years, is assigned to a preceptor. That's somebody who's done the job at that hospital before. They followed them around, they learn, what they're doing. but at the same time, they are providing services to that hospital's patients. And so I think the distinction that you are drawing is that this person is taken out of productive work. This person is placed in a truly exceptional situation that I frankly haven't seen before. And so I suppose there is language that could be crafted to address the situation that you have, but I would argue and I would support instead the amendment that talks about a portable credential, because that is something that is black and white that employers and employees can rely upon.
Follow-up, Senator?
Quick follow-up. Yeah, thank you. I think coming out of the construction world and very similar to the manufacturing world, I would argue the point that many times they're not necessarily looking for that person that has the diploma or a certificate. If you have the skill or the willingness to learn, they're going to bring you in. And so you're right. They probably, if the situation I gave, you're not going to have a credential on a piece of paper that shows that I have this training. But honestly, if somebody who runs a manufacturing facility, if somebody comes to them coming out of a trade school with a piece of paper that says I have the training to do this, and another person is coming saying, I've worked for 5 years for that company doing this work, odds are the person with 5 years experience is getting the job even though they don't have the credential. So it may not be a physical piece of paper that says it's a transferable credential, but it is a skill that that person can take with them wherever, which is going to lead to a higher wage and benefits wherever they go. So,
Ms. Prakash.
Thank you. I hear you, and I somewhat agree. I think the problem, and at least what I have seen and what my clients have experienced, is that there are many employers, unfortunately too many, who are not doing what you are describing, but may characterize it in the exact same way, as we are putting you through a specialized training. You are going to have marketable skills at the end of this, above and beyond what on-the-job training is. And the challenge, respectfully for you all, is to figure out how to draw that distinction between the employers that are taking advantage through the characterization of something and employers who are truly providing something akin to an apprenticeship that would be accepted from the ban.
Great discussion. Thank you very much for the questions and for the responses as well. If you don't mind staying, there may be more questions. And I would just also, because we're just talking about this right now, I would also, what brings to mind for me is this idea of the trap. There are lots of ways that an employer can entice an employee to stay on, whether that's great working conditions, benefits, pay, all sorts of ways to do that in order to recoup that time, recoup that labor that don't involve trapping the person in a situation where they could be making more elsewhere or getting better benefits somewhere else. So that to me is a huge part of the piece here as well. Senator Kupek.
Thank you, Madam Chair. I'd like to just maybe, a few of these I think I know the answer to, but then I just kind of want to hear them out loud again. But just maybe a few hypothetical situations to just run through, particularly now with the A4 amendment on there, how this changes things. So in terms of a relocation agreement or a sign-on bonus, let's say I take the sign-on bonus and then I run away after 2 days with my sign-on bonus. Clearly, I was not a beneficial, and maybe I was a terrible person. But is there a way for that employer to recoup that sign-on bonus? Or, I have literally seen where somebody paid to show up. They showed up at the door and said, just before I got here, I got a better offer in a different part of the country, and I'm leaving. Is there any way to recoup like a relocation money on that? And then I'll have a couple of other scenarios, but those two for starters.
Senator Mann and or Ms. Prakash.
Thank you, Madam Chair. So that was purpose of the amendment, to make sure that those recruit, but again, I'm happy to add clarifying language.
Senator.
Good, thanks. And again, knew the answer, just wanted, again, make a couple of these things. And I'm assuming on the, I know there are some employers that will offer just like, we'll pay your college tuition, and it may not be at all related to the job, but it's like, you come here, you work, we'll get you college tuition. What if that person, turns out they fail out of school or something along those lines? I'm just, these are just hypotheticals that have crossed my mind.
These are great. Senator and/or Ms. Prakash.
Thank you, Madam Chair. So if the employer is paying for the tuition, it can be reimbursed based on the stipulations in the amendment.
Very good. Senator, follow up?
Okay, and then, and I'm assuming, and I just wanted to clarify this, it was line, about the employment. So let's go, I'm thinking particularly of like a commercial driver's license. There are lots of places that say, come work here, we will give you the commercial, we'll train you for the commercial driver's license and do that. If, let's say you're a terrible driver and you're constantly running into mailboxes, and you cannot get your commercial driver's license, is there, what happens there? I mean, clearly that was like, you had to have this to get the job. So what, in that scenario, any reimbursement on that, or they clearly can't do the job because they hit mailboxes?
Senator or Ms. Prakash.
Thank you, Madam Chair. So that would fall under a transferable credential that can be recouped by the employer.
Okay.
Thank you.
And then one last question. On the prorated side, it's, the language is just kind of, it's prorated. Is there any kind of, do you think we need any tightening up of exactly like prorated how? Weekly, monthly, something, or is that just TBD?
Senator or Ms. Prakash on the
Madam
proration.
Chair, generally, it's the amount of money divided by the amount of time. But I don't know if that's state statute somewhere.
Right, yeah, I'm just thinking like, if I have an agreement and I'm like, I've worked 23 of my 24 months, and then lo and behold, my dream job shows up and I'm gonna leave. But I work, I get paid monthly, but I worked, maybe I only had 2 weeks left. I don't know. Is there, do we base it on a pay period type thing just to know? Because then they could be like, well, you left in the middle of the month and you got to pay us a month, but maybe I really only had 2 weeks left, but they don't do that sort of thing. I don't, it's just,
Sure.
just
Any
off
thoughts,
the top of my
Senator?
head.
Or Ms.
Madam
Prakash?
Chair, Senator, I think that would be spelled out when you start the job.
Okay,
No, thank you.
that's it.
Any
Thank you, Madam
follow-up?
Chair. Thank you.
Thank you, Senator Kupek, for the scenarios. I think that's actually really helpful because when around this topic, I think all of us do think of these situations where an employee can get a lot of benefit from an arrangement as long as it is clear and they actually proactively agree to it and it's fair. So we just don't want people trapped in these situations where they can't get out. Senator Dornick.
Thank you, Madam Chair, and Senator Mann. Just to the hypothetical that Senator Kupek brought out with the signing bonus and relocation, where in the amendment is that? Is that specified in the amendment or in the bill?
Senator Mann?
Madam Chair, I think it was supposed to be under subdivision 4, and I think there was discussion too that those things didn't fall into a trap agreement in the first place. But again, I feel like there's been so much discussion on it that I, again, more than happy to write clarifying language for those pieces. That is the intent.
Thank you, Senator. Any follow-up? Okay. All right. Members, it is our intention to move this bill forward to the Judiciary Committee and then to request that it come back to the Senate Labor Committee. And it sounds like there is room and an invitation from Senator Mann also for some discussion. If people want to do a little bit more tweaking and work on this bill, I encourage you to talk with Senator Mann because we would really like to move forward with this legislation and protecting Minnesotans. So with that, Do I have a motion that Senate File 2533 as amended be recommended to pass and be re-referred to the Committee on Judiciary and Public Safety? Senator Marty makes that motion. All in favor say aye. Aye. All opposed say no. The motion passes. Thank you very much, Senator Mann, and thank you very much to all of the testifiers who joined us today to share your perspectives. And members, with that, the Senate Labor Committee is adjourned. Have a good afternoon.